The Honorable Adrian G. Sal, Judge presiding. All persons having business before this court draw near, give attention and you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
All right, well, counsel, good morning to each and all of you. Welcome to the 5th District Court of Appeal. We are here this morning for oral argument in one case, that is case number 23-1407, and forgive me if I mispronounce it, Fotonico, is that right? Fotonico versus Wilmington Trust et al. I want to, if I may, first introduce the panel this morning. Seated to my right, your left, is Judge John Harris, who is the longest-serving member of the court on this particular panel. To my right is, of course, Judge Jordan Pratt, and I am Judge Adrian Sal, and we will be addressing the matters pertaining to this case. Let me, if I can, use this time to remind everybody, if you have cell phones with you, if you'll be kind enough to turn those cell phones off to ensure the proceedings are not distracted, that will certainly assist us. I wanted to, if we can, also remind everybody that these oral arguments are recorded and posted on YouTube. They're also live streamed for purposes of the arguments today as well. And finally, customarily 5 minutes is reserved for rebuttal time for appellants. If you prefer a different time, if you'll certainly let us know that, then our marshal, who is handling the clock for you and for the court, can make those necessary adjustments. With appellees having with more than one appellee before the court, if more than one counsel is going to make the argument, of course, you'll share the 20 minutes and we will leave it to you to divide up amongst yourselves how you wish to prefer in that regard. With that understood, counsel for appellant, you're welcome to proceed, sir.
May it please the court. Presiding Judge Sal, Judge Harris, Judge Platt, Marshal, opposing counsel, good morning. My co-counsel Brian Rich and myself, Doc Blanchard, appear today on behalf of the appellant Fotonico LLC. Fotonico appeals the denial of its motion to surcharge the receiver and Wilmington, the bank, for funds that it alleges were improperly paid to a buyer on a foreclosure sale. The law is clear that those funds should have been paid to the owner of record as of the filing of the notice of lis penens.
If they're surplus
was
funds,
the owner of
they're to be
record.
paid if they're surplus funds.
Yes, sir. And that's one of the problems. What happened was, in this particular case, the receiver properly paid $487,000 plus to Wilmington before the sale. It didn't show up on their records. They then had the sale on March 9th of 2022. They then continued to receive monies, approximately $74,000, and then distributed $187,458.82 on April 14th, more than a month after the sale, to the buyer. They distributed they then received the $487,000 back from the bank, and they can't explain why. They say it was a mistake that they paid them in the beginning, but had they paid the bank, that would have reduced the debt that Fotonico would have owed the bank, and therefore there would have been a surplus. There was no surplus because the monies were already at the bank and they came back to the receiver. The receiver then paid the buyer again $485,151.66 on April 26, 22. Those are all documented in the record at 1683, 1684, 1685, and 1686. The Florida statute and the case law that has been decided by this court and many other courts is clear that any monies that are owed to the bank should be paid first. Any costs associated with the foreclosure proceeding should be paid. But if there are funds over that, they go to Fotonico. The opposing counsel and the appellees have failed to cite a single case that says that is not the law. The cases of this court and the cases of other courts hold that clearly. The statutes, 714 clearly says that. And they say that the receiver is not discharged until he files a final report. When we got the reports that we got, we learned that these monies had gone in and out. We couldn't explain why. We objected to any further accounting, and we made a motion to surcharge the receiver and the bank for these payments that were improperly made. That was what this proceeding was all about. The court, noting that it's a difficult decision, relied upon some language in the final judgment. Well, I think it's not, first of all, I don't think it follows Florida Statute 714, and I've cited that in my brief, all of the different phrases. I don't think it follows the case law of this court and other courts that say that the funds belong to Fonaco. It said property. Well, the property that was sold to the buyer on the certificate of sale, which I've cited and is in the record, was the land. And that was it. They bid enough money to have a 99-cent surplus. But they got $687,000 over that. They didn't bid for it. When the courthouse clerk said, "Hear ye, hear ye, hear ye, I'm selling this property," they sold the property, the land. And that's what the buyer bought. But the buyer got an additional $680,000. Now, it is confusing, and that's the reason I filed my supplemental brief. And because the monies received after the sale are not the total $187,000. They total $74,000. I've got a list of all of them. It's in the record. I can tell the court $2,000 some odd on March 10th, $15,000 on March 11th, $3,000 on March 15th, and it goes on and on and on, $10,000 on March 23rd. This is all after the sale. If they had given them to the clerk, there would have been a surplus. They didn't give them to the clerk. They didn't give them to the bank, which would have reduced the debt that Photonico owed. Photonico borrowed a certain sum of money. During the COVID crisis, this is a shopping center that involved medical offices, restaurants, and service salons and things like that. When the COVID crisis came, it shut the business down. And Photonico became a default. No question about that. We cooperated. Photonico cooperated with Wilmington to go ahead with foreclosure, not a contested one. They wanted a receiver. We didn't object to the receiver being appointed. We had no idea how much longer it was going to take. The final judgment is correct. The amount of money that's owed, that's correct. But they were paid. It doesn't address these funds. What are they? Well, you're right. The general definition of surplus is money that the clerk is dispersing. It never got to the clerk, so the clerk wouldn't know. And we raised that in every single one of the
Is that the
motions.
only aspect of the definition for surplus?
Monies that the clerk has either over or under the bid and the amount owed.
Would the surplus not be the amount for which the property was sold and amounts remaining after all liabilities are paid?
Yes.
I know it comes from the sale.
Yes.
Okay.
Yes.
Okay.
And that's our whole argument. Why in the world would the buyer be entitled to it? There's absolutely, and I asked this
Isn't that what
question.
the final judgment says?
No, it says property. And the
Well, it
property,
says receivership property.
yes, the property is defined elsewhere as the land. And that the judge said that
How
property would
is
include.
receivership property defined?
Sorry, sir.
How is receivership property defined, either in the judgment or a statute? Doesn't it specifically include rents received?
Yes, sir. Up to the
Why aren't
amount,
these rents receivership property?
up to the amount of the debt.
Well, that's not what the definition says.
That's what the actual summary judgment says.
The statute,
it says-
statutory definition of receivership property just says it includes any rents received.
Correct. It says, the statute 714 says, the receiver shall collect the funds of operating the foreclosed property during the period of the foreclosure for the purposes of collateral for the debt. What the statute says. Now, the judge made an order that we didn't object to at the time. There's no reason to object to it. The amount of money was correct. We had no idea what it was going to sell for. We even asked the receiver and the bank, well, did you expect there was going to be a surplus? No. Well, what happened is after the COVID crisis passed, the shopping center filled up again and started generating profits. That's the reason there's this extra money. Now, the receiver, however, did not file a report for February. The sale was in March. We didn't learn of these transactions until we were able to get the bank records and cite the funds in and out that I've just told you about. Again, they have not cited one single case. I've cited 4. Not one single case that says the buyer is entitled to these funds, except their argument on property. I accept that, but I don't think that argument is fair. I also think it doesn't follow the law. It's in direct dereliction of Florida Statute 714, which cites the duties and liabilities of the receiver. And it should be noted that the receiver is not discharged until the filing of a final report and the court orders it being discharged. That still hasn't happened. Technically, the receiver is still the receiver. No order has been entered discharging the receiver, and the statute specifically says the receiver stays there at the discretion of the court. They've cited issues, well, we didn't get permission to sue. We didn't sue. We objected to the final accounting, which is the right way to do it, and that's what the court has said in the case of Rodriguez versus Federal National Mortgage Association at 220 Southern 3rd, 577. There's a reason for this. There's not supposed to be a windfall or a loss. At the beginning of this, when the final judgment was entered, the highest contemplation would be there would be a deficiency. There wasn't, because of the change of circumstances totally beyond the record, which was the passing of the COVID crisis and the tenants coming back and incomes coming forward. Based upon all of the record that we've cited, I believe, and I haven't heard an argument that says it's not true. I've heard, well, they followed the final judgment, they should have done this, they should have done that, but they don't cite a case that says the buyer is entitled to it. It is our position that the court erred, and the court should be reversed. The court should be directed to enter an order granting our motion to surcharge against the bank and the receiver. Thank you very much.
Thank you, sir. Counsel, you may proceed.
Thank you, Your Honor.
And for the court's benefit, are you going to be arguing for both?
Yes, Your Honor.
All right, very well.
Oh, no, I apologize.
All right.
I should have listened a little bit closer. What I was going to announce to the court on my appearance is, my name is Carl Pearson, and I'm representing the receiver in this matter, and my co-counsel will be representing the plaintiff, Wilmington, the other appellee in this matter. We're going to attempt to split our time evenly.
All right, very well.
May it please the court, counsel. As I've indicated to the court, I have the pleasure of representing the receiver in this matter. The receiver, for just a little bit of background, I know the justices have looked at the briefs, was appointed September 17th of 21. The Uniform Commercial Real Estate Receiver Act came into effect approximately June or July of 2020. Part of his order was that his powers and duties flowed from the Uniform Commercial Real Estate Receivership Act, and of course part of the order and also the Receivership Act places the receiver duly appointed by the court as an officer of the court, appointed to preserve the property, and in this instance to collect receivership property. The court, in its order dated September 17th, ordered that the rents be collected by the receiver, that the receiver collected those rents in its trust account, and those rents are included in the definition of receivership property, as Judge Harris noted. The order appointing the receiver had a section in Section 12, and it provided that the monies collected by the receiver, the receivership property, would be used as collateral of the loan and to maintain and protect the collateral. There are 3 items that were set forth in paragraph 12, and that actually said that the receiver will pay the plaintiff the amount of the receivership property under 3 circumstances, whatever occurred first. a sale or the foreclosure sale, meaning a regular sale where another party bought the property from the trustee, the final judgment terminating the receivership estate, or further order of the court. What then happened was the court entered its order of final judgment of foreclosure February 2nd, I believe, and of 22. And in that order, the court changed the dynamics of what was going to happen with the receivership property. The order was submitted to both parties. Counsel at the hearing in front of the court on January 17th said that there was no objection to the form of the order. Paragraph 10 of the order of summary final judgment provided that all receivership property shall be transferred to the successful purchaser of the mortgaged property. The receivership then, after that property is transferred, automatically terminates and the receiver is discharged. And all that has occurred. The property went to sale on March 9th, and an anomaly occurred that doesn't happen in 99% of the cases. A good faith purchaser purchased the property for $14,409,449 and met all the requirements for the clerk, and ultimately deposited those funds into the clerk's registry. The clerk compared the final judgment of foreclosure, distributed the funds that were dictated by the court as to how those funds would be distributed to the plaintiff, Wilmington, and had a balance that the clerk, in the record, the clerk executed the certificate of disbursement. It specifically provided the amount that was dispersed to the plaintiff, and it specifically noted that the surplus retained by the clerk was 99 cents. 5 months after the certificate of disbursement was filed, the defendant, Photonico, filed a motion to surcharge the receiver. The receiver, before the sale occurred, filed 4 receiver reports. 2 of them actually were the January 31st month-ending report, so they were exactly the same. And in those reports, in the public record, in the court file, it showed that the receiver had approximately $500,000 in its trustee account at that time. Anyone comparing the summary judgment order to the receiver report would know that if they were the successful purchaser of the mortgage property, that the receiver would transfer the receivership funds that were in that account to the successful purchaser. When we had the hearing in front of the court, the transfer of the receiver's money, which was not called for, not pursuant to the order, out and back, was only a mention. It did not become a front issue until the reply brief was filed herein. The trial court considered 2 issues. Was the property, the receivership property, surplus, or was it receivership property, the money that was held in the account? And after argument and briefing by the parties, and that issue being the preeminent issue, was it surplus, was it receivership property, what was the amount, was argued then in the briefs and before the court, and then again in the motion for rehearing. And the court, in its ruling, succinctly stated in its ruling that I reviewed the case law and the cases supplied. The court took into consideration the argument of the parties, and the final judgment is going to rule the day in this case. The rents collected by the receiver are not part of the surplus funds under the statute. There's no case out there that supports that, in my opinion, based on my review of the case law. But paragraph 10 of the final summary judgment of foreclosure specifically says that all receivership property is to be transferred to the successful bidder, and that's what happened in this case, and that's what the parties bargained for in supplying the court the final judgment that they did supply, which included paragraph 10, which I have already advised the court. So, in the off chance that in this case, a successful bidder bid the entire amount of the final judgment with 99 cents left over as surplus, the receiver thereafter transferred the entire balance of the receivership property to the buyer as it was supposed to do, according to the order, and then the receivership was ended pursuant to that order, paragraph 10, and the receiver was discharged. And that's what the court found, and that's what happened in this case. The statute, the receivership statute, the court's two orders in this case govern the acts of the receiver. The receiver complied with those, especially with paragraph 10 of the summary final judgment of foreclosure, and the surplus funds, which at the time he filed his last report, because February had not yet finished, the January 31st report showed that the receiver's account had receivership property of approximately $500,000 for him.
It seems, Mr. Pearson, to be a dispute whether the receiver has been formally discharged.
My esteemed colleague argues that, but I think the order is pretty clear that he discharged his duties, and paragraph 10 of the summary final judgment ended the receivership and discharged the receiver all in one swoop.
Paragraph 10 specifically says the receivership shall automatically terminate and the receiver shall be discharged and released from any further obligation under
Correct,
order.
and that is the position of the receiver in this case. That ends my argument. Thank you, Your Honor.
Thank you.
Good morning, judges. My name is Fred Carter. I'm with the Venable Law Firm in Washington, D.C. I'm appearing here today on behalf of Wilmington Trust, who is the plaintiff in the underlying foreclosure action. I'd also like the record to reflect I'm appearing today with our Florida counsel from Schutz & Bowen, Todd Coburn. There's just a few things I want to say. I don't have a whole lot to add to Mr. Pearson's excellent presentation. I adopt all of his arguments, but I represent the secured creditor in the underlying foreclosure case. We, of course, look at this through the lens of the lender, and I want to share that perspective with the court to help the court draw what I think are the obvious inferences from the appellate record here, which I think will help the court come to the right decision, which is to sustain the trial court's rulings. The starting point for the presentation from the lender's point of view is that the only reason why this foreclosure has come to an appellate court level is because this foreclosure was a full pay foreclosure. Those are not what you normally get in a foreclosure case. Normally, when a commercial lender is going to be foreclosing on a piece of real estate, they're foreclosing because the property is worth less than the debt. That's why you're in foreclosure. A lot of what I'm going to be saying is going to be responding to these new arguments that were raised in the final reply brief that got filed by the appellants. And these are the inferences I think the court can make from the record that we have here. There's nothing nefarious at all that occurred with regards to transfer of funds between the receiver and the lender. Nothing nefarious at all. We get a judgment of foreclosure. It gives us a foreclosure amount. At that point, all we're owed as a lender is what's in the judgment. Our loan documents have merged into that judgment. All we get is the judgment amount plus the post-judgment interest that the state of Florida says we're entitled to, which I think is 4.25% right now. That's all we're going to get between the date of the judgment and the date of the foreclosure sale. After we get the foreclosure judgment in, the receiver looks at the receivership order. The rents I'm holding are secured creditor collateral. In a normal case, the secured creditor is going to wind up taking that property through a credit bid because, again, the property's not going to be worth what the debt is. So what did the receiver do? Sent some of that money to the lender. Now, we're talking about the period between the entry of the judgment of foreclosure and the actual foreclosure sale itself. What does the lender do with that money? They hold it in suspense to see what happens at the foreclosure sale. The foreclosure sale comes in, and the Florida system is a beautiful system. You load your bid amount into the computer as, for the online auction sale. Mr. Coburn did that. I was up at my office in Washington, D.C. with the whole sale thing on the computer, and I watched it all happen. It's blazingly fast because of how the bidding information's all loaded up into the computer. And lo and behold, within about 90 seconds or 2 minutes, we'd been paid in full. So what do we do then with the rent money that had been sent earlier by the receiver to the lender? We take a look at the foreclosure judgment. And what does that tell us? That money goes to the purchaser. Under normal circumstances, of course, if the bank were to take the property through a credit bid because the property's underwater, the lender would have been the purchaser. But they weren't in this case, much to our happy surprise. It turns out to be 2775 Biscayne Holdings LLC, whoever they are, real estate investors from South Florida. So that money had to go back to the receiver so the receiver could fulfill his duties under the receiver order, because paragraph 10 is really clear that's what has to happen. It's clear, so's the Florida statute. It's come up a couple of times in the court's questioning today. Chapter 45, the foreclosure statute, is very precise in its language. The borrower, whoever the borrower is, when the lis pendens gets filed, is entitled to a surplus on foreclosure. But the statute expressly states that it's the amount of the surplus reflected in the certificate of disbursement. The same statute even lays out what the language of the certificate of disbursement is supposed to say. There's not a whole lot of thinking here. The statute does all of our thinking for us. So the 99 cents, Mr. Blanchard's clients, welcome to the 99 cents, although I'd point out that the foreclosure article of 45 does allow the clerk of the court to charge a $15 fee for every disbursement they make, and the amount of the fee that they'd have to collect to disperse the 99 cents is more than the 99 cents. But that's really why we're here, is because we had a credit bid that paid us all in full. It's not the normal paradigm for a commercial foreclosure. Upon realizing that the judgment had been paid in full, the debt owed to the secured creditor is completely extinguished. They have no right for a penny more. The money had to go back to be administered by the receiver pursuant to Article 10 of the receivership order. And that's really what's going on here. Clearly, the rents themselves were receivership property. The Florida Receiver Statute says so. It's also embedded thoroughly in several provisions that we point out in our briefing in the receivership order. Receivership rents are not sale proceeds under the Florida statute. That's, as Mr. Pearson said, those arguments are just as simple as they can be. I also want to help the court a little bit understand where we're at with regards to the status of the receiver and his discharge. Because paragraph 10 of the judgment of foreclosure says, as soon as I think it's the certificate of sale is filed, it's not the certificate of disbursement, I think the certificate of sale gets filed, the receiver is discharged. And I think we went into this in one of the earlier trials, in one of the transcripts from one of the earlier proceedings down at the trial court level that we had. This provision of the judgment of foreclosure was jointly drafted. Mr. Blanchard was correct. The borrower did not oppose our summary judgment motion. We prepared the judgment and we sent it over for comment. And the comment we got, it's reflected in the transcript, in the record, it's pages 1749 to 1752. The provision that they commented on was paragraph 10. And specifically the provision requiring immediate discharge of the receiver. Why is that there? Well, I'll tell you why it's there, and that is that this is not the first foreclosure I've done in Florida recently, since the pandemic. It's not the first foreclosure I've done in Florida involving Mr. Rich. Before I did this foreclosure in Central Florida, I foreclosed on the Doubletree Hotel in downtown Tallahassee, and the borrower's counsel was Mr. Rich. And that was a hotel foreclosure, which is different than a shopping center foreclosure, because a hotel is more of an operating business, right? An office building, shopping center, you're just kind of collecting rents. There's not a whole lot going on, but a hotel, a full-service hotel like the Doubletree, is a real operating business. And it took a long time for us to get the receiver discharged in Tallahassee because we had lingering post-foreclosure issues with regards to transferring vehicles that were covered by certificates of title, and we also had problems transferring liquor licenses, which we had to do to get the purchaser everything that they would purchase. It was a little bit of a mess, and it took a long time to get those issues resolved, and we needed to have the receiver involved to bring those things to resolution, and Mr. Rich did not want to go through that again. And so we baked into this judgment that the receiver would be done as soon as the foreclosure was over. That's the mystery about where the discharge provision of paragraph 10 of the summary judgment comes from. And I hope the court will find that bit of background instructive in terms of why it deviates from what's in the receiver statute. And with that, I think those are the key aspects that I wanted to share with the court from the lender's perspective in terms of what happened here, what Florida law requires, and why the decisions made by the trial court should be affirmed by the Court of Appeals. I don't have anything further.
Thank you, sir, very much.
We know the receiver wasn't discharged on the certificate of sale because they continued to receive monies, $74,000 in the next month. They continued to act as the receiver. 714 specifically says that the receiver is not discharged until filing a final report and approved by the court. That's what the statute says. Florida Statute Section 45032(1)(c) states, surplus funds or surplus means the funds remaining after payment of all disbursements required by the final judgment of foreclosure and shown on the certificate of disbursements. They couldn't be shown on the certificate of disbursements. The clerk never got them. The receiver never sent them to the clerk. Had they done that, there would have been a surplus. We didn't know that at the time. The final judgment of foreclosure. Upon issuance of the certificate of title, all receivership property as defined in the order appointing receiver shall be transferred to the successful purchaser. They didn't have these funds at that time. They got them afterwards. Now, 74,000 versus 187, that's what got us confused in the very beginning as to that other payment. But they didn't have at least $74,000 at that time. Florida Statute Section 714(1)(6)(3). After judgment is entered against the property owner and with court approval, this is the significant part, they never got court approval. With court approval, in the action in which the receiver is appointed, a receiver may use or transfer receivership property other than in the ordinary normal course of business with court approval, which they never got. Florida Statute 714(12)(2)(c) provides that the use or transfer of receivership property other than in the ordinary normal course of business, as I've just noted, must be with court approval. Such approval was never given, and we didn't know about it. We had no way of knowing about it. Even the court recognized in its discussion that he says, the court recognizes you wouldn't have known about it till you got the bank records. As soon as we got the bank records, we objected. The order should be reversed with directions to enter judgment as requested in the brief. Thank you.
Thank you very much. All right, with oral arguments concluded on this particular case and for totality of the court's business, a second case which was set for oral argument had to be canceled and will be addressed by the court by future order. With that concludes our work today. We will stand in recess.
All right.